Hello viewers, welcome to my channel. I'm Hasham. So now I'm going to start the first topic on the subject business law. Last video I have made a short video I have made on the meaning, importance, scope of law. What are the different branches of law? So before starting the subject business law, a student must be completely aware about the meaning of the term law, branches of law, and what are the sources from which Indian business law was made. And what are the constituents of this business law? All these things I have explained in the last video. So if you have not watched the first video, I suggest you to go to the playlist of my channel. Select the subject business law. Watch the first video, then you can be able to understand now. Now I am going to start the first topic of business law. In this video, I am going to explain you about the contract. What is a contract? All contracts are agreements, but all agreements are not contracts. What are the essential elements of a valid contract? And what are the different types of contracts? These three questions may be asked in examination very frequently. In almost every examination, they will ask one question regarding this one. What is a contract? All contracts are agreements, but all agreements are not contracts. Elaborate. And what are the essentials of a valid contract, and what are the different types of contract? Now watch the video till the end to get the complete command on this topic. Now, first of all, I'm starting with the meaning of a definition of contract. So according to section 2H of the Indian Contract Act, a contract is defined as an agreement enforceable by law. Very easy definition. Section 2H of the Indian Contract Act defines the term contract. It is an agreement which is enforceable by law. That is contract. So if we if we discuss this definition, we can say a contract is nothing but an agreement between two or more parties which will be enforceable by law. So there should be an agreement between two or more than two parties, and that agreement should be enforceable by law. Then only that agreement will become a contract. So the contract consists of two elements. Every contract must have two elements. The first one is agreement, and the second one is legal obligation, that is enforceability by law. So these two are the main ingredients of a contract. If any one of these is not there, there is no contract at all. So in simple words, we can say a contract is equal to agreement plus legal enforceability. So contract, agreement plus legal enforceability. That's all. So first of all, we'll study about agreement. What is an agreement? So again, section 2E of the Indian Contract Act defines the term agreement. What is that? Every promise and every set of promises forming the consideration for each other is an agreement. So these are the definitions given by Indian Contract Act. So the students must remember this definition. You should not, you cannot change the definition. Meaning you can write in your own words, but definition same to same. For example, section 2H has defined the contract. A contract is an agreement enforceable by law. That's it. That is the definition given by the Act. Similarly, what is an agreement? Agreement definition has been given by section 2E, where every promise and every set of promises forming consideration for each other is an agreement. Then the question arises, what is this promise? Again, section 2B defines promise as when the person to whom the proposal is made, gives his assent, signifies his assent thereto, the proposal is said to be accepted. When the proposal is accepted, it becomes an agreement. Again, I repeat, this is the definition according to section 2B. Promise. What is a promise? A promise as when the person to whom the proposal is made, one person is there, he is giving some proposal to another person. The other person gives his assent regarding that proposal. Once he accepts that proposal, it will become an agreement. Example, Mr. A proposes something to Mr. B, and B agrees to that proposal. That agreement comes into existence. That is the agreement according to section 2B. In simple words, an agreement is made when one party makes a proposal and the other party accepts that proposal. That means offer plus acceptance is equal to agreement. So for this agreement, two conditions are there. First of all, for making the agreement, two or more than two parties must be there. A single person cannot make the agreement. So there should be two or more than two persons to form the agreement. Secondly, there must be consensus ad idem. Consensus ad idem means both the parties must think on the subject matter of the agreement in the same terms at the same time. Same terms and at the same time. When two persons are discussing about the subject matter in the same time at the same way, then there is consensus ad idem. So to make the agreement, there must be two or more than two persons and there must be consensus ad idem. Right? Now that is the agreement. Now second one is legal obligation. The parties who are entering into the agreement must have an intention to create legal obligation. If there is no intention to create legal obligation, there is no contract at all. That's why the agreements of social in nature, moral or religious, all these things, there is no intention to create legal relationship. That means it will not become a contract. The agreement will remain agreement itself. It will never become a contract until and unless there is an intention to create legal relation. An agreement becomes a contract only when it results into legal obligation. If the agreement does not hold the capability to establish a duly enforceable by law, then it cannot be a contract. Therefore, the agreement is a wider term than contract. Contract is a part of agreement. Agreement is a very wide term in which enforceable agreements as well as unenforceable agreements will come. So agreement is a very wide term, whereas contract is a short term. That's why it is said all contracts are agreements. All contracts are agreement, but all agreements are not contracts. There are many agreements which does not become contract. Which does not become contracts. So agreements which are social, moral or religious in nature cannot become a contract as they cannot be enforceable by law. So these agreements will remain agreement itself. If it's a social agreement, if it's a religious, moral agreement, religious agreement. So these are outside the scope of enforceability. So in short, we can say agreements that are enforceable by law are contracts. But those agreements which give rise to social obligations do not become contract. Example, A invites B for dinner. A and B are friends. So A has called B on dinner. But at the time when B reaches A's place, A cannot be able to provide the dinner. Now B cannot sue A because it's only a social agreement. It is not a contract. Because there is no intention of the parties to create legal relationship. It's a social agreement. So it will not become a contract. So we can say all contracts are agreements, but all agreements are not contracts. So what I have explained so far, the meaning of the term contract, according to section 2H of the Indian Contract Act, a contract is an agreement which is enforceable by law. And according to section 2E, what is an agreement? Every promise and every set of promises forming consideration for each other is an agreement. Then what is a promise? When the person to whom a proposal is made signifies his assent thereto, then the proposal is said to be accepted. When the proposal is accepted, it will become a promise. It will become a promise. So, two things are there. That is, agreement is equal to offer plus acceptance. Then the parties must have the intention to create legal relationship. Then only the agreement will become contract. That's all. Now, the next thing is Essentials of a valid contract. In examination, very frequently a theory question will be asked regarding what are the essentials of a valid contract. According to section 10 of the Indian Contract Act, all agreements are contracts if they are made by the free consent of the parties competent to the contract for a lawful consideration with a lawful object and not expressly declared to be void. This is the definition according to section 10 of the Indian Contract Act. Again I repeat, all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void. So all the ingredients of a valid contract are given in this section 10. Now we can elaborate it. So essentials of a valid contract according to section 10. What are the essential elements? The first, offer and acceptance. Every contract must have an agreement. Without agreement, no contract. And every agreement must have offer and acceptance. One party should give the offer and the other party should accept that offer. So until and unless there is no offer, no acceptance, contract will not arise. So every agreement, every contract must have a valid offer and a valid acceptance. That is the first ingredient. Second, purpose to create legal relationship. When two parties enter into a contract, enter into an agreement, both the parties must have the intention to create a legal relationship. Suppose if there is no intention to create legal relationship, that agreement will remain agreement only, it will not become a contract. That's why social agreements are outside the ambit of a contract. Social agreements are only agreements, it will not become contract. There is a well-known famous case on this point called Balfour versus Balfour, where there is an agreement. The husband promises his wife that every month the husband will pay 300 pounds to wife, household allowance. Later on, both wife and husband separated. After separation, husband fails to give the household allowance to wife. Wife sued in a court of law. The court dismissed the case, saying that it is only a social agreement. It's a personal social agreement. It cannot be called a contract. There was no intention to create legal relationship. So Balfour versus Balfour case is the famous case on this purpose of establishing legal relationship. Next, lawful consideration. Consideration means something should pass from one party to another party. When he gives something, he should get some benefit. So every party should get something in return. So something in return is called consideration. The consideration should be lawful consideration. So if there is no lawful consideration, there won't be any contract. No consideration, no contract. The consideration may be past, present or future consideration. Right? Next one is capacity to party. Every person can enter into a contract if he is of the age of majority, is of sound mind and not expressly declared that he is incapable. So normally when a person will become incapable, if he is a minor, if he is below the age of 18 years, minor, if he is unsound mind, if he is lunatic, then in that case, idiocy, in these cases, a person cannot enter into a contract. So capacity of contract says only major persons, sound mind persons can enter into a valid contract. Free consent. Consent means the intention of the persons. That means the understanding of the persons in the agreement. The consent, the free consent will be affected due to coercion, undue influence, misrepresentation, fraud, mistake. On account of these things, there is no free consent. If there is no free consent in a contract, the contract will become voidable at the option of one of the parties. One of the parties can avoid the contract if there is no free consent. Next one is lawful object. The object of the contract should be lawful. It should not be illegal. It should not be immoral. It should not be opposed to public policy. That means the object of the contract should be lawful object. Next one, writing and registration. Actually, the contract, the agreement may be oral or written. Oral or in writing. But some special cases are there where the law says the agreement must be in writing and even must be registered. Then only the contract will become a valid contract. Next comes certainty. That means the subject matter must be certain, must be clear. It should not be ambiguous. It should not be vague. That means the terms of the agreement should be clearly understandable. There should not be any ambiguity in the agreement. Next, possibility of performance. The contract will be valid if it is possible of performing. If an act which is impossible to perform will be void ab initio. That means any act which is beyond the possibility of performance, it cannot be performed. Then the agreement, the contract will be void ab initio. Next, not expressly declared to be void. If any law has expressly declared that this agreement, this contract are void, then it will not become a valid contract. So these are the essential elements of a valid contract according to section 10. Now the next point is types of contract. The contracts are divided into different categories on different bases. So what is the first base? Classification based on validity. Classification of contracts according to validity. So according to validity, first one, valid contract. A valid contract is that contract which contains all the essential elements specified in section 10. In section 10, whatever essential elements are there, if all the elements are satisfied, all the essential elements are there in the contract, then the contract is called a valid contract. Then voidable contract. Voidable contract means it is enforceable at the point of view, from the point of view of one party, but not at the point of the other party. For example, if a contract is vitiated by free consent, if there is no free consent in the contract, then it may be enforceable at the point of one party. It is not enforceable from the point of view of other party. It is voidable contract. Similarly, void contract. A contract may be enforceable in the beginning, but later on it will become unenforceable. It is called void contract. Beginning it was enforceable. For example, A enters into a contract with B that I will sell you 1000 kilograms of grains which are on the way. That means through ship. Through ship the grains are coming. After reaching the port, I will sell you 1000 kilograms of wheat. Suppose this is the agreement. But unfortunately, the ship sunk. That means the wheat has not reached the port. Then the agreement, the contract will become void contract. Initially it was enforceable, later on it has become void. Next is illegal contract. If the law prohibits, if the law restricts any act, and if the parties perform that act. For example, the law prohibited certain goods to be imported from other country. There is a contract made between A and B to import that goods which are prohibited by the law. It is called illegal contract. Next is unenforceable contract. The contract will become unenforceable if there is a technical deficiency in the contract. If there is some technical deficiency in the contract may be unenforceable. This is a classification on the basis of validity. Now, classification on the basis of formation of the contract. On the basis of formation, expressed contract. When the terms of the contract are expressed either by words or in writing, orally or in writing, it is called expressed. When A and B enter into a contract, A has said that I want to sell this commodity at so and so price. B has given the acceptance, yes, I will purchase this commodity at so and so price. There is an express contract. That means the terms and conditions are expressed by the parties. Offer and acceptance are expressed. That is called express contract. Implied contract. The implied contract will not be expressed but deduced from the circumstances of the case. Deduced from the circumstance of the case. For example, a person enters into a public transport bus. As soon as he enters into a public transport bus, a contract comes into existence. The bus department is offering the services. It is not necessary that the passenger has to accept the offer. As soon as he boards a bus, a contract comes into existence. That is implied contract. Horsey contract. Horsey contract really are not contract at all. It is neither implied nor expressed, but the law has put the parties in such a conditions as if there is a contract. As if there is a contract between the two parties. Example, by mistake A has left some goods at the house of B. By mistake, A has left some goods at the house of B and B has consumed the goods. Now it is the responsibility of B to reimburse A. Actually there is no agreement, but the law has put the parties in as if there is an agreement. That is called Horsey contract. So next one is classification based on performance. On the basis of performance, the contracts can be classified as executed contract. When both the parties has completed their obligations, it is called executed contract. Example, A sold car to B and B has paid the price. A sold his car to B and B has paid the price. Both the parties has completed their obligations. It is called executed contract. Executory contract. When one or more of the parties has completed the contract, whereas the other or others have not completed their obligation. That means one or more have completed, the others have not completed their obligation. It is called executory contract. Unilateral contract. Unilateral contract means one party has completed his obligation, whereas the other party has not yet completed his obligation. One party completed, the other party not yet completed his obligation. It is called unilateral contract. Bilateral contract. When both the parties have not yet completed the contract, not yet completed their obligation. Example, A will say, next month I will sell you the car. B will say, okay, I will pay you the amount next month. So both have entered into the agreement. Both have not completed their obligation. A said, I will deliver you the car next month. B said, I will pay you after getting the delivery. So bilateral contract. Both the parties have not completed their obligations. So three things I have explained you in this video. The first thing, what is a contract? A contract is an agreement enforceable by law. So here I have explained you what is agreement, what is the enforceability of law. Secondly, section 10, what are the essential elements of a valid contract? And lastly, what are the different types of contract? Now, in the link I have given some problems on this topic, on this essential elements of a valid contract. I have given the practical problems in the link. Take a printout of these problems. I am explaining you the solution of these practical problems. The first practical problem says A invited B on birthday party and B promised to attend, but B did not reach the residence of A on that date. A invited B, listen carefully, A invited B on birthday party and B promised to attend, but B did not reach the residence of A on that day, while A made very good arrangements. Can A recover damages from B? Can A recover damages from B? A invited B, but B has not turned up. B promised that he will attend the birthday party, but B has not attended the birthday party. A has made good arrangements. Now can A sue B for damages because B has not attended? The court says A cannot claim damages from B. because there is no intention to create legal relationship. When A invited B, the intention between A and B is not to create legal relationship. It is only a social agreement without any enforceability by law. So in this case, A cannot claim damages from B. Second question, A agrees to pay B rupees 2000 and in consideration B agrees to write him 500 pages within 10 minutes. Is it a valid contract? Listen carefully. A agrees to pay B rupees 2000 in consideration that B will write 500 pages within 10 minutes. Is it a valid contract? It is not a valid contract because this contract lacks the ability to perform. That means possibility of performance. It is not possible to write 500 pages in 10 minutes. To write 500 pages in 10 minutes, it is not possible. So lack of possibility of performance, this contract is unenforceable, not a valid contract. Now third question, state giving reasons whether there is any contract in the following cases. The 4 cases are given, each case whether it is a valid contract or not. First, Salim and Salma promised to marry each other. Salim and Salma promised to marry each other. Yes, it is a valid contract. Second, Akash takes seat in public vehicle. Yes, it is a contract. Because as soon as a person boards a public transport vehicle, a contract comes into existence. It's an implied contract. Then Sushil and Anil agree to go to fishing. 2 friends are there. Sushil, Anil, both agree to go for fishing. It's a social agreement. There is no intention to create legal relationship. So there is no contract. Pratap invites Rana to a card party. Rana accepts the invitation. 2 friends are there, Pratap, Rana. Pratap invites Rana for a card party and Rana accepts the invitation. It's only an agreement. It's only a social agreement. So there is no contract, no intention to create legal relationship. That's all. Next, 4th question. Shahid agrees to bring gold from the moon by driving a car. Is the agreement valid? Shahid agrees to bring gold from the moon by driving his car. Is the agreement valid? No, it is not valid because it lacks performance. It cannot be performed. Possibility of performance is not there. There is no possibility of performance since a person cannot go to moon by driving his car. So it is not at all possible. So the contract is not a valid contract. Next one, 5th problem. Ajay agrees to sell Vijay my white horse for rupees 500 or rupees 1000. Is the agreement valid? Again I repeat. Ajay agrees to sell Vijay my white horse for rupees 5000, for rupees 500 or rupees 1000. Is the agreement valid? No, the agreement is not valid because there lacks certainty. There is no certainty regarding this proposal. He is saying that my white horse for rupees 500 or for rupees 1000. He has not quoted a specific price. He is giving 2 prices. So which price should be accepted? So there is lack of certainty in this proposal. So the contract is not a valid contract. Now, A promise, next one, 6th one. A promises to pay B rupees 1 lakh if he kills C. A promises to pay B rupees 1 lakh if B kills C. B kills C, but A refuses to pay. Can B recover the amount? No. B cannot recover the amount because it's an illegal contract. The object is not legal. For a contract to be a valid contract, the object should be lawful. Lawful object should be there. Killing a person is not lawful. Killing a person is not lawful. So an agreement to do an unlawful thing is not a valid contract. Now B cannot recover the amount. Come on, 7th problem. A invites B to dinner at his house on Sunday. B hires a taxi and reaches A A's house at the appointed time, but A fails to perform his promise, can B recover any damages from A? Now A is inviting B. Friends are there. A invites B for dinner at his house. B has taken a taxi, and after spending so much of money, he reaches A's place. But A has not provided the dinner. Can B sue A for damages? No, because it is a social agreement. When A invites B, their intention was not to create legal relationship. It is only a social agreement. So in this case, B cannot recover any amount as damages from A. Next, 8th problem. If father promises to pay his son rupees 500 every month as pocket money, later he refuses to pay, can the son sue his father for the agreement? No, not at all. Because when father promises to pay some pocket money, 500 rupees every month to son, their intention is not to create legal relationship. It is only a personal agreement. Their intention is not to create legal relationship. So in this case, son cannot sue his father for getting his pocket money. Next one, 9th problem. A promised to obtain for B employment in public service and B promised to pay rupees 10,000 to A. Is the agreement valid? No, the agreement is not valid, because getting an employment in public service is against the law. So the agreement is not valid. Last one, 10th is the last question. A husband promised to pay his wife a household allowance of rupees 2,000 per month. Later the parties separated and the husband failed to pay the amount. The wife sued a case of allowance. Will the wife succeed? The points in this case are exactly same as Balfour versus Balfour, where a husband promises his wife to pay household allowance of rupees 2,000 every month. Later on, wife and husband separated. Now husband has not paid the allowance, stopped payment. Wife sued in a court of law. The court dismissed the case, saying that it is outside the ambit of law, since when husband promises his wife to pay household allowance, it was only a social agreement. It's only a personal agreement. There was no intention to create legal relationship. So the wife cannot get the allowance from the husband. That's all. So these are the 10 case laws I have explained on this topic of contract, essentials of a valid contract, and what are the different types of contract. So first video I have completed on business law, and in this video I have explained 3 topics. What do you mean by contracts? And explain all contracts are agreement, but all agreements are not contracts. So whatever I have explained, that will be enough. Then secondly, what are the essentials of a valid contract according to section 10? And lastly, what are the different types of contracts and case laws? These are the things I have explained. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel. Inshallah, in the next video, next topic I'll take up on business law.